Hello and a very warm welcome, everyone, to our LiveLaw's Practitioner Series. And this time has really been a horrendous time for lawyers and really people, across all sections of society. But one thing that we've been able to do during this time as advocates is spend our time in sharpening ourselves with the law and really learning from eminent persons at the bar. So today's topic is on the future of advocacy. There are some things in advocacy that are beginning to change with technology and the dawn of a new era. But at the same time, there are possibly fundamentals about advocacy that are never going to change. And for today's talk, we have with us Senior Advocate C S Vaidayanathan. And Sir really needs no introduction. But nevertheless, let me just briefly bring to light a few facts about Sir that we may not know and just trace a successful journey at the bar. So at the age of 19, when most of us would probably just be going to college, Sir had the distinction of graduating with his law degree at the age of 19. And quite obviously, he was then too young to enroll at the bar. So he worked with a corporate company for about 4 years. And then in the year 1974, he joined Senior Advocate K.K. Venugopal, who is our present Attorney General of India. And Sir practiced in his chambers in Chennai. And then somewhere in the year 1979, Sir moved with Mr. K.K. Venugopal to New Delhi and began his practice in the Supreme Court. He enrolled as an advocate on record. And then Sir, since then, has gone on to argue many landmark cases. In 1992, he was designated as a senior advocate. And some of the landmark cases that Sir has argued include landmark pro bono cases. And one such case is the case of Sebastian Hungary, which is a habeas corpus petition where people were illegally abducted by security forces in Manipur. And that was possibly one of the first habeas corpus cases in which compensation for violation of civil liberties was awarded. And that's just one of many successful cases that Sir has argued. And without taking any further time, let me hand over to Sir to begin with his talk on the future and the art of advocacy. Sir, over to you.
Good evening, friends. Abhishek has started me on a trail of memory. So let me start with my story. Let me start the story of the courts in the last 50 years. In 1970, I got enrolled, though I suspended practice because I was the corporate with DCM in Delhi. So when the first case, I think, of importance, which I witnessed, was not as a lawyer because I had suspended practice, but that was the Keshavan Bharti case, which was going on in 72, 73. And 13 judges, so very ponderous and luminescent arguments, intellectual jousting at the bar, and very incisive interjections and questioning, and equal quicksilver responses from Mr. Palkivala and Mr. Sirvai. I think that was, I had the pleasure of watching it. But the court was sitting in a 13-judge bench and hearing the most important case of the entire Supreme Court. I would say even today that has been the single most important case of this history of the Supreme Court of India. So therefore, they devoted considerable amount of time. They had the luxury of time and leisurely arguments. So that from there, when I started practice in 74 in Chennai, now that was a different world altogether, and every day in the writ court, you would find 70, 80 matters being listed. And you will find, and the very different, today what we see in Supreme Court is that the judges read up and come. But in Madras High Court those days, nobody would have read the papers in advance. So, but the arguments were effectively put over in a matter of 2-3 minutes. And 70-80 admissions will get over before the judge by lunchtime, and he would start the final hearing. And similarly, the appeals would be first appeal and second appeal will not be longer than 1.5 to 2 pages. And the crisp, sharp questions of law would have been there, and the oral arguments will not be very long. And I think 25-30 appeals admission would be taken up and very quickly. There were some judges who were a little slow, but most judges, without even having read the papers, would be able to catch the point. But I think the advocacy skill of the lawyers was also important, because they were able to put over their case in 2-3 minutes. That was the important thing. And the judges used to ask very incisive questions. Though it's not very relevant from the point of view of today's subject, but I think one thing that I wanted to mention in my experience as a lawyer in Madras, 74 was the time when MISA had been amended and a lot of people had been taken into custody, and then Coffee Posa was imposed in 75, so and during emergency. Habeas corpus petitions would be heard. If it is filed today, it will be listed tomorrow, and it will be taken up for a year. Then there was no question of counter affidavit, etc. habeas corpus. The file had to be produced. In 24 to 48 hours, the habeas corpus petitions would be disposed of. I think there is something which we have lost over the years. I think the urgency in regard to dealing with personal liberty matters, which was very much there in 74 to 77, unfortunately has been lost. Anyway, this is not connected with today's subject, but I think it is of interest, topical, therefore I thought I must mention. Now, petitions will never be long. Writ petitions, suits, plaint. You know, Mr. B.K. Thiruvenkathachari, who was the Advocate General for a long time. He was not the Advocate General at that time, but he used to tell me, and look, why do you make a 5-page sale deed for transfer of a property? Transfer of Property Act provides the format. You need the seller, you need the buyer, you need the consideration, you need the description of the property. Rest of it is covered by Section 54 of the Transfer of Property Act. You don't need so many clauses. So all these put together cannot be longer than 1.5 pages. That was all that was needed. Equally, a plain, you know, somebody will really have to sit and write a plain. If you dictate, you are going to make it long-winded, which is what is happening. Technology today is being abused even by judges and by lawyers, because cut and paste means you take out from everywhere and then put it in. I have seen judgments of Justice Bashimayangar and Aladi, Justice, some of the judges of the Madras High Court, half a page, 1 page handwritten judgments. See, when you sit and write, your thoughts are also clear, and if you dictate and you ramble and you have a lot of things. Therefore, precision in drafting is one of the most important things. Now, if you, in select cases, of course, there will have to be elaborate arguments. And even there, Ms. Nambiar, Mr. Vangapal's father, you know, he would, when he gets the brief, when he has to get ready the argument, he used to have a green notebook, and in a green pen he will make notes. And once he has prepared it and kept it, then whenever the case is called up, even after 2 months or 3 months, he has studied it in depth, collected the case law, looked at it, decided which he is going to use, what are the facts that he is going to, so everything is in his notebook. So deep thought goes in the chamber before you actually advance arguments. It is not as if you just go through the brief selectively and then you go there, and then judges also are flexible, give you sufficient time, you start arguing and then develop the point as it goes. No, I think the people like Ms. Nambiar, they would put down their thoughts, the propositions, and the and enunciate them before court in a focused manner. That was how it used to be. When I came to Delhi, I could see two contrasting positions. In Supreme Court, most judges used to read the briefs and come. In the Delhi High Court, most judges would not. But, you had some judges like Justice Chinnappa Reddy on a Monday or a Friday when miscellaneous matters used to be taken up. He would have, for 40, 50 matters would be listed. He would have read, and therefore he knew exactly what order he was going to pass. Whether the counsel was there or not, he was going to. It is only if he's going to pass an adverse order that he will pass it over, even if the counsel was not there. Otherwise, he will issue notice and grant stay or admit the matter. That used to be, number of judges, they had read the matters. Equally, in a very, very felicitous manner, you could see Chief Justice Prakash Narayan, Justice Kripal was sitting with him in Court 1 at that time, before he came to Supreme Court, and he was, when I came in. And they had not read the papers, but just as the writ admission judge or the appellate judge or the first appeal judge in Madras High Court used to do, they would quickly understand the point, and the lawyers were also, able to put over. But today, the long-winded arguments which are going on was something which used to happen only in very, very important select cases, not in all kinds of matters. And that was the experience that I had. Now to come back to the present, we are going through a very, very exceptional situation. In the last 50 years, I have seen a lot of changes. The lawyers and the judges. Even today, most judges in Supreme Court read their brief fully and come in advance, and at least all the relevant judgments and some important document. And I think Delhi High Court has also substantially changed from what it was earlier. Now there also the judges read and come. So today, I think there is a need for us. See, our relevance as lawyers is only when the credibility of the institution is at the highest, when the faith and confidence of the people is at the highest. Now, if we are not able to deliver justice to the consumers of justice, then it gets shaken. Now, it is something which has been debated over the years. If you have 3.5, 4 crores of cases pending in the country, and time lag due to which people should not be encouraged to take law into their own hands. They should still go through the system of courts and to get justice. That is part of our role as lawyers. If we have to enable the people to continue, not merely to continue to have faith, but to enhance their faith and confidence in the system. How do we do that? Now, we have seen a number of amendments which have been made to the CPC, to the Criminal Procedure Code. The provisions of special provisions have been made in regard to Commercial Courts Act, etc. In spite of all that, I personally feel both the judges and lawyers have been very, very reluctant to make changes which are necessary. We inherited the British system, but in the United Kingdom today, there is a substantial change. There are case management hearings which take place. Time is given. Now, just as in US courts where the time for argument is 1 hour slot or whatever it is not that strict in UK, but even then, the registrar, the court manager, as it were, will ask the parties, how much time do you need? And mind you, it's going to Ultimately, in taxation of course, it is going to have an impact. Therefore, when the lawyers give an estimate, they have to give a reasonable estimate. If the judges find later during the hearing that you have unnecessarily wasted the time of the court, if they could finish in half an hour what you have estimated as 2 hours, they are going to penalize your client. Therefore, and it will cast a reflection on the solicitor and the barrister and the client. Therefore, this case management hearing has become very, very important, where directions are given in regard to the written submissions. And see, if you go to an attorney's firm in USA or a solicitor's firm or in the chambers of barrister in UK, you will find that they set apart hours, days for the purpose of preparing an important case. It is not as if the previous evening they get the brief and they go through something and then next morning they come and they prepare it fully. Therefore, in chamber there is a discussion, and I mean, for important US Supreme Court cases, time given is 1 hour for both sides put together, including the rejoinder. So there are rehearsals held in regard to what questions are likely to come from the court, and you prepare the responses. So therefore, there is a discussion amongst the lawyers. 4 or 5 lawyers put their heads in, apply their mind. What is the likely question that is going to be shot at you from the court by the judges? Therefore, you prepare your response for that. I don't think in the chambers here that kind of intense preparation is done. There are some lawyers who think about it and then write down what likely questions that are to come, and therefore they prepare the responses. But it is not everybody who does it. Somewhat, I think we take it a little casually. If I may say so, I think the approach needs to change. Our skill set will have to now develop these kind of preparation. See, there is no point in having your Supreme Court rules where you have in Order 19, Rule 33, the statement of case shall consist of 2 parts. Part 1, concise statement of facts. Part 2 shall contentions of facts and law with the case law, all that kind of a thing. And you have similarly in the commercial courts, you have the amendment of Order 18, where there is a requirement that you shall give written arguments and the format is prescribed. Now, detailed rules have been made by Delhi High Court in regard to all this. But I think what needs to be done is every lawyer either will have to be put through this kind of skills training or will have on his own to undertake this training and then be ready for this. It is very important. And I think there is a need also for unlearning some things and relearning some new things, not only for the lawyers, but also for the judges. I think judges also need to be from time to time educated on some of these aspects, and more particularly today in the context of what is happening in regard to e-courts, virtual hearing. I think there is a great need for that. Now, see, my experience as an advocate on record, if I may indicate, see, those days the briefs used to come by post. The air transport facility was not all that good. So by afternoon or evening, the brief would have come from I was an advocate on record for 13 years, 79 to 92, till I was designated. So the advocate on record, the advocate in Chennai or Cochin or whoever is sending you a brief will send it, so you get it. So I will go through, and normally I will dictate a synopsis, and take it from me, my synopsis will never be longer than 1.5 pages. I will try to make it in 1 page, The longest that I have ever done is 1.5 pages. The list of dates briefly, subsequently. But if I can't put over a case in Supreme Court, which is the highest court of the land, in one page, you can take it from me, the attention span of the judges is not, you are not going to hold their attention. You must be able to, whatever is the most important case that you can think of, you should be able to put over your point in 1.5 pages. And I see today the synopsis running into several pages. And it doesn't have any impact on the judges. You see, we are here as lawyers to ensure that our clients get justice. For that, you have to be in a position to attract the attention of the judge to the injustice that has been done, the injustice that will have to be remedied, and the point that they will have to consider for that purpose. So we should be able to bring it in focus. And once you catch their attention, if they get attracted by that 1 page, 1.5 page synopsis, then they will look into greater detail on the judgment of the High Court and whatever documents are necessary. And therefore, you must give reference of it in the synopsis itself. What is the relevant page based on what is there? So that will have to be given so that they don't have to search for it. That should be there in the synopsis. The relevant pages should be there. And if you are relying on some judgments, which is the most important, you mentioned that the highlight that will have to be done in the synopsis. But this will have to be, I don't think it should take more than 2 pages at the most. That should be the point. And the petitions of appeal or specially petitions also, see, we have there is a greater need for, we all in our school days used to have this composition, pre-C writing and all that. I don't know whether it is there today in the school. But pre-C writing skill is very, very important. We should be able to, if you read a story for 5 pages, you should be able to summarize it in 1 paragraph. Because that is a pre-C writing skill. And a good lawyer should have that skill. That is because in advocacy, you have to know what is the limited time. And therefore, when I come back to today's position, see, the judges are working under tremendous strain. You take it from me when people say that judges are having so much of vacation, holidays and all that. This is complete nonsense. Because most judges are spending their time in the evenings and in the weekends studying the brief, dictating judgment. And if they don't get even a 3 to 4 weeks vacation or a 5-week vacation where they can go and recharge their batteries, I'm afraid that they will not be able to do justice to the role that they have to play. Therefore, no, if with all this pressure on them, if you have to get justice for your client, then you must be able to put over your case in a very focused manner. That is why the brief, the synopsis followed by crisp lists of dates, omit all that is unnecessary. For the point that you are putting over, whatever is the relevant date alone take. There must have been several events which are completely unnecessary for the point that you are putting over. So take only those relevant dates. And then whatever is the proposition of law and support it. This should be the speaking brief. And if they catch that, if they read and come, then whatever, if they have any doubts, they will put that. And you can be ready to answer that because you know what is your, if there is a borderline case, you know what is that question on which there is going to be doubt. Therefore, you must be ready to answer that. If you have a very, very good case, then of course you may not have lost at all in the High Court. But in any case, having lost, you must be able to focus on that and then put over. Now, I think these are some of the things which I thought I must, in my opening remarks, indicate, and then I will, depending on your questions, whatever I am willing to respond.
So thank you so much for sharing your experience and specifically all those practical insights. Now, so when you look at advocacy, many people obviously focus on the courtroom because that's where it comes into public view. But 9/10, many say 9/10 of the work in any case is in the chambers or is pre-courtroom. So, sir, if you could just share with us what your mindset is, what your preparation is, whether it's in terms of meeting the clients or looking at what are the facets of a case I must put together before it goes to the courtroom. Can you just share with us some of your practical experiences there?
Yeah. See, today, of course, as a senior counsel, I don't meet the clients, but other lawyers come. But I have had as an advocate on record, and prior to that, when I was practicing in Madras, I've interacted. I think the one most important thing as a lawyer we must remember is never accept anything as given. If question everything. If there is something which is said in any judgment, in a lower court judgment when you have to appeal, which doesn't appeal to your common sense, then it can't be right. You have to, if your common sense is sharp enough, is developed enough, and if it doesn't appeal to your common sense, then there is something wrong. Then you have to look for what is wrong. Therefore, either the law or the law itself may be bad. Therefore, when you challenge the validity of a law, so you look for this. When you say something is unreasonable or arbitrary, then why do you say that? Because it is, to your common sense, it doesn't sound right. Therefore, then you start looking at, okay, first, legislative competence is one part of it. Then you look at from the point of view of violation of rights. Therefore, you scrutinize it from the point of view of is it consistent with the fundamental rights or various other restrictions imposed. Therefore, scrutinize that, and then just because a law has been made, if it doesn't appeal to your common sense, if it doesn't appeal to your sense of justice, question. There must be a ground to question. That's, I think, is the basic thing. Second, I think when you talk to the client, there are clients who have from the commercial world, business world, they will be more focused. There are persons who are, the labor and service cases. They're so intensely affected personally. They have so much to unload on you. Therefore, in those cases, if you are meeting the client, I think you have to be also a kind of a counselor, not merely a counselor, a lawyer, but sometimes you have to, because they need the comfort. They want to unload it on you. So you have to give enough time. Then from that, chisel out what, according to you, are the relevant facts for the purpose of putting over. And that too, when you are drafting an original petition, this becomes even more important. Therefore, that is the second set of clientele. You have, therefore, different sets of people you have to tackle differently and try to find out what exactly, because but most of us today in Delhi are persons who are not dealing so much with the original petitions, except the writ petitions or some original suits, exceptionally, which you deal with. So there you look at it. And there it becomes necessary to, I think, one other important thing I personally believe, and I don't rely exclusively on the briefing of the advocate on record who briefs me, or the counsel who briefs me, or the junior who briefs me. I make it a point as far as possible to go through the entirety of the brief. I may not read every page, but every document I know at least what it relates to, whether it is relevant. If it is relevant, I'll go through that. And that's how I have developed the practice, because I think that's very important. We should be able to in case some questions come, we should be able to deal with it. And sometimes, every time you read the statute, or every time you read Article 14, you will find a new facet. It is, you might have read it 100 times, but every time, say, some particular section is involved of the Contract Act or the Transfer of Property Act or anything, read that statute again and again, because then you will develop there are new facets which always come in. I think that's you. And, there are lawyers who have become attorneys general in the for the country, like S. V. Gupte, Lala and Sinha. For them, the first thing was, in fact, S. V. Gupte never had a library, only Bare Act, and he will go through the Bare Act and from that develop the argument. Case law, he will rely less and less. But that's a kind of, therefore, there is so much to be learned from the kind of, and they would never argue for long, put over the point and with precision. So that is what is needed. And therefore, the preparation in chamber in regard to each one of these, look at the law, the Bare Act, what is the law that governs its statute, and then the case law can always be worked up. And today, case law digests are so easy. Those days we used to start with all these 15 years, 50 years digests and quinquennial digests and all that. Today everything is available and you Google for it and then you get it. Therefore, it's much easier. But there's a lot of time will have to be spent. And I think, see, whilst narrating the facts to the court, whether in writing or to the court, confine yourself only to those specific facts which are relevant for the point that you want to put over one point. Then you come to the next point. If any fact is relevant, you go to that. Otherwise, we are taking too much time and the judges will lose their patience also. So the proposition of law that you put over this, I think the chamber work that is important. And very often in regard to questions of law, you will find it useful to have, if you have a sounding board with whom you can debate and then see what can come out of it. It's a very important thing. See, my senior, Mr. Vanagopal, with him, one could have an intellectual debate always, and he will encourage that. And, that is how we all grew up in that chamber. But, it's a delight to be in that chamber, and then he will be willing to debate, discuss, be open for discussion, and then so that he can also prepare in anticipation of what the questions are going to come from the court. This is a kind of preparation that he has trained us for.
Sir, thank you for that, sir. Again, going back to your pre-counsel drafting days, we see a lot of advocates who are experienced. They can just sit down and in one sitting, it flows like magic out of their mouths. A whole draft comes out. And sometimes when we're drafting, particularly as younger lawyers, we can get a mind block, or you're not sure which direction our draft needs to go in. Is there a specific way in which you approach a draft structurally? You talk to us about how initially, yes, it's important to read the law. It's important to understand really what the client wants. But is there a way in which you do a rough first draft? Do you try to formulate the relief first? Is there a structural way to approach your draft in a way that it flows better?
I'll tell you, I was very fortunate when I started in 74. Mr. Chidambaram and I used to share a table. And in Mr. Vanagopal's office, the client, we'll start the work in the evening at 6 o'clock. So the client and they comes in. And in Madras, the practice, Madras, Kerala, Karnataka, Andhra, all these places, the senior advocates will run an office, and therefore the clients used to come and they will decide, okay, who will looking at the subject, which is a lawyer who is competent to handle it. So I have seen, the way, and normally what used to happen was the client will come in the evening. In most of the cases, the petition, the papers will be seen, the petition will be dictated in the evening. Next morning, those days cyclostyle. So the stencils will be brought in the morning for correction. Then it will be rolled. By 10:30, it will be filed, and if urgent orders are needed, it will be mentioned at 10:45 in the morning in Madras High Court. 2:30 lunch motion. The order, if it is granted by 5:30, the order will be available, and the client the next evening will. So within 24 hours, the whole thing would have been done. That used to be, and there was no difficulty in listing. In the normal course, next day it will be listed. If you need very urgent orders, lunch motion. No, but the point that I was trying to make was, Mr. Chidambaram, he will go through, that's how I learned, and I started following that. He'll go through the papers, talk to him, clarify. In his very small letters, he will note down the and the conceptual clarity that he has, even today, unbeatable. Certainly. So 1, 2, 3, 4, the points he will note down and start dictating then and there. And that is how we all got trained. Therefore, we used to do that. And so as an advocate on record, when I started here in 79 also, normally that is how I would dictate that, and then let my juniors complete the specially petition or writ petition, whatever it is, and that will be done. And within a day, it will be. So most matters are capable of being done. There are some where you will have to think of what because there may be issues which might have been already decided by some courts. Therefore, you are faced with a problem. Look, this is already foreclosed, so you examine. Then you have to see what is the other new area that you can possibly develop. These are some issues which we have had to discuss, and particularly in politically sensitive matters, these do call for. The other area where some amount of research, deep analysis will have to be done, and you can't overnight dictate, and therefore a draft will have to be prepared, etc. Where today, in all these big commercial matters, when financial implications are huge and the contracts are very, very long. Contracts run into hundreds of pages. So you have to do a deep analysis of this. It is not easy. You have to do that and then look at what is the financial impact. And therefore, today, one of the important skills that we as lawyers have to develop is to be able to read the balance sheets and profit and loss account and work out the cost, the viability of a project. These are important aspects. I think what is the financial impact of any of the relief being X or relief being Y or of no relief? We should be able to put over to the court also. One of the things that I have always been stressing is that sometimes the judges also do not consider the financial impact of their judgments. There has been debate. People have been saying, look at this setting aside of 2G licenses or of coal mining leases, the impact that it has had in regard to the non-performing assets, etc. I think there is a need for the judges to be just as the parliamentarians and the legislators will have to have an understanding of the impact on judiciary. Judicial impact assessment needs to be done by the legislators. The judges have to do an impact assessment in regard to the lives of people, in regard to the commercial life of the people, in regard to the economic strengths and weaknesses of the country, how it will impact, the growth, how it will impact. I think some of these public interest litigation, particularly, we need to have an impact. And the other thing today is the environmental aspects. I think from the point of view of lawyers as well as judges, every case, what is the impact that it will have on our life in terms of environment? I think is another aspect which needs to be stressed in the law college and thereafter as lawyers when we grow up. I think this is another area which needs to be studied.
So, that's very useful, and it really gives us a lot of insight into how much strategizing in terms of brief is needed, sitting down with the client, and from here you say is the best to learn.
I think you are not audible. I think your connectivity.
So now stepping into the. Sir?
You're not audible.
Can you hear?
Yeah, I can hear you now.
Okay. What is preparation, and particularly during hearings, when you have only around 30 seconds on whether a case gets. Sorry, am I audible?
Yeah.
Okay, sorry for that interruption. So now stepping into the courtroom, admission hearings barely get 30 seconds to a minute. And again, taking you back to your pre-senior counsel days, when maybe the court would give you a less of its year. What would be your preparation then going into an admission hearing? Would you anticipate questions from the bench? Would you again prepare and bounce off ideas of your colleagues the previous day? How would you prepare for such an admission hearing? Even today.
Normally, when I was an advocate on record, the point that I was going to make is what I would incorporate in the synopsis, in that 1 page or 1.5 page synopsis. So I know what I'm going to focus on, and I know that if in in the 1 or 2 points that I'm going to focus on, if I don't succeed, it is unlikely that I'll be able to proceed. No point, arguing all points with equal emphasis. You know what is the point that will appeal. But of course, when you draft a petition, you don't know the judge before whom it is coming. So one important factor that you have to take into account is what is the background from which the judge comes. What is his approach to particular type of matter? You knew, for example, there are certain judges who are generally conservative and would not interfere in matters which are sensitive, politically sensitive, or they give the more leeway to the government. That's one thing. Okay, there are matters relating to rent control or service or labor. There were judges who had definite views in regard to that. Land acquisition matters, you know, if it goes before ex-judge, it is going to be very big. Therefore, you should be able to discover a point which will appeal to the particular judge. So that is the next stage. When you draft, you don't know before whom it is going. So when the matter comes up and when the list is, before the judge before whom it is coming, that is why it is important as a lawyer, even for a beginner, irrespective of whether he has a case or not, the lawyer, he or she must always attend the court, because then only you will be able to see what is the reaction of the judges to various issues which come up. What is their approach? Now, therefore, you develop an understanding of the judge. It is important because then you know what is the point that you will stress. Look, if it is a compassionate judge, even if you are weak on law, sometimes you may be able to get a notice issued from the point of view of settling matters, trying to see whether somehow it can be resolved by appealing to his good sense, because he is compassionate, okay, humane. This is something that will appeal to you. Therefore, that is a point that you will put over. I think the advocacy skill is has to be honed to also suit the approach of the judge, the mental frame, makeup of the judge. So each one comes from different backgrounds. Therefore, each one has gone through several experiences, and therefore their reactions today in court are shaped by the background, the environment in which they have come up, and the type of cases that they have dealt with. So we should be able to anticipate the reaction, and it is not going to be uniform. I mean, the fact that today one judge has issued a notice, tomorrow after notice it may go before some other judge, his approach may be entirely different. So you will have to focus on something else. I think, therefore, the day before the case comes up, that is, you don't strictly go by whatever you have prepared at the time of drafting. You will now have to also evolve in tune with what you anticipate from the judge before whom the matter is listed. That is something which over years, by your experience, training, you will develop by watching the judge, by understanding the judge, and then put over.
Thank you, sir. Am I audible?
Yes,
sir. Yeah. Just to get to a next question, sir. How do you deal with a judge who is hostile in terms of aggressive skills? You have been witness to even other doyens at the bar, right from Mr. Nani Palkiwala to Mr. Fali Nariman. What are some of the skills you have picked up along the way on the art of persuasion, particularly when a judge, you realize within your first few seconds that the judge is definitely not with you?
So I'll narrate to you one or two cases. I think one of the most persuasive lawyer in a hostile court, I think, has been Mr. Ashok Sen. And, Mr. Nariman had argued, Dr. Chitle had argued, and I think one more, Mr. Sarabji had also argued. Then Mr. Ashok Sen came as the fourth lawyer. And the bench was a very strong bench. Justice Tulsapurkar, Justice Desai, Justice A.P. Sen. Very strong judge. Now, the Justice Desai went hammer and tongs at Mr. Sen, and Mr. Sen started at around 3:15, 4 o'clock court rises. So for 45 minutes, he had a terrible time. And they said everything has been argued by the three previous counsel. What is there, Mr. Sen, and all that? He somehow managed to survive till 4 o'clock. And next day, mind you, he came and completely changed. In the 2 hours that he had the next morning, he had changed. So he knew what were the questions that were coming, and the man, Mr. Sen has a phenomenal memory, and he can 88 Calcutta Weekly Notes, page 138, at right hand column, 10th line. The way he could take out the case, that was the kind of memory, and therefore for all the propositions that were being put to him, and to counter that, he got ready and he was sharp with his answers, and he was able to. But of course, for 45 minutes the previous afternoon, he had to manage, somehow narrate the stories, keep everybody happy, and then he had to get ready. Next day he did that. I think, see, the one important point, in fact, I think in our training, thanks to Mr. Vanagopal, Mr. Vanagopal always enjoys being before a hostile court, because that is a challenge. You have to take up a challenge and then be able to convert the judge, if possible, to your point of view, and then put forth the case. See, a lot depends on your conviction in the case that you are arguing. Therefore, if you are if you are convinced of your case, convinced in the sense, if you feel broadly that there is, you are trying to argue for justice for your client, and yes, he has been wrong, and therefore, I'm sure that conviction will go a long way. Therefore, that the passion with which you are able to put over and show to the court, even in a hostile court, look here, there is some injustice that has been done. You can't possibly argue that when you know that, you are doing your duty as a lawyer, but you don't have that amount of conviction in your own client's case. Very often it happens when you are a law officer, you have to appear for the government, and you can't argue with the same amount of conviction. But of course, there are law officers and law officers. And as a law officer, I think it is important. A duty, all of us have a duty to the court to be fair. But as a law officer, you have an extra duty, because very often, if you feel that an injustice has been done to a petitioner, a citizen, as a law officer, I think it is obligatory on a law officer to set it right if possible before the case comes up, or tell the court, look, I think something, some relief may have to be given. Let me see whether I can get it done. Otherwise, you mold the relief in a manner. I think sometimes you will have to concede the case. That's in a hostile court also, sometimes there are points on which the bench may be hostile to you. Some points you may not be able to convince the court, but there may be other points which may be appealing. Therefore, you will have to tell him, look, yes, there is a problem here, but I will come back to it. Let me deal with this other issue and then come back if necessary to that. If I'm able to convince you on that, then I will, it may not be necessary to go into it. That you will have to, therefore, skillfully manage the court in a manner that you will have to carry them with you.
So let me now pivot really to the future of advocacy. And we are in a time in which physical hearings are virtually impossible. And so we had to move to virtual hearings. Now, where do we go from here, even when the pandemic begins to cease and we can go back to physical hearings? Where do you foresee in the Indian context, how can we use technology? What reforms can we really bring to make sure that justice is more accessible? At the same time, justice is also speedy.
I think 2 or 3 things. One, see, virtual courts cannot replace the physical courts, but they can supplement. I think we should envisage a situation where, even if we can start with about 20% of the cases being heard on a virtual hearing basis. Now, it is today, sitting here, I'm able to appear in Chennai or Indore or Uttarakhand or Delhi, wherever it is. Now, this is a great facility. Earlier, till March, all of us, if it was a Chennai hearing, I give up all the work here, I go there and appear. Now, this is very, very big advantage that we have all realized. And mind you, the person, the client or the lawyer who has a case in Chennai or Cochin, he can address the court here with equal facility. He doesn't have to come. He doesn't have to come and brief a lawyer here, depend on a lawyer. He's the lawyer who had argued for him in the High Court, and therefore who is fully familiar with the case. If he is confident enough, if he is in a position to do that, he can argue also. Therefore, I think we should not completely, even if physical court become possible with, if we find a vaccine and then it becomes easier for the physical courts to resume. Even then, I think we should not completely disband or dispense with the virtual court. We should continue, if possible, to some extent, and then see how best we can have a combination. There can be, see, I tell you, arguing before Justice A.C. Gupta, who was an arbitrator, having retired, and I'm talking about 1988, and Mr. Dipankar Gupta was counsel on the other side. And 1988, we were debating the possibility of virtual hearing of this kind with me sitting, and Mr. Dipankar Gupta had not shifted to Delhi at that time. He was in Calcutta. Justice A.C. Gupta was in Calcutta. I said, we should be in a position today with technology to have my arguing from Delhi, Mr. Dipankar Gupta arguing from his home in Calcutta, and you are sitting at home and hearing. This was what I was talking about a good 30 years ago. And today it has become feasible, and we are doing it. People are sitting in houses. I am doing arbitration where 3 judges are sitting in respectively in their houses, one in Bangalore, 2 in Delhi, and I am arguing from here, and counsel from elsewhere. So it's happening. Hearings are taking place in Singapore, London. Regularly, counsel from London is appearing in Supreme Court today. Therefore, that's happening. Therefore, this convenience is important. The technology has given us this advantage. We should use it. At the same time, there are cases where we cannot but have physical hearing. There are cases which cannot be disposed of in the time slot of 10 minutes or 15 minutes or half an hour. There are cases which need some longish hearing. But even there, I think it is important to stick to some time schedule. And I'll tell you, see, people may have different views in regard to the Ayodhya case, but the way it was managed from the point of view of court management and time management, I think we have to give full marks, because enough time was given, but time limits were stuck to. And therefore, we knew if in my rejoinder, in the initial arguments, ample time was given, but in the rejoinder, limited time. Therefore, I knew if I'm going to have half an hour, 1 hour. So I have to be very precise and stick to that time. And the judges, all 5 judges were very keen that all of us stick to that time. And I think remarkably, we were able to finish 2 days ahead of what was originally planned. So the 41 days, and it was a case which involved huge, massive documentation, 80,000 pages. Therefore, and so many texts, academic research had to be done. All this was done. But with all that, I think the intense homework that was done by all lawyers ensured that we were able to stick to the time limit and put over the case. Now, therefore, in the days, in the courts that we see tomorrow, I think all of us need to spend more time in preparation than taking it easy in preparation and going and assuming, taking it for granted that we will have ample time in court to develop an argument in a leisurely pace. That time, I think, is gone. And look, our first duty is to the people. Our duty is to the courts, but our first duty is to the people. People have been waiting for justice. So don't tax their patience anymore. We have to ensure that we have to deliver justice to the people. Therefore, I think we have to consciously adopt a policy of written brief and limited oral argument. This is very, very important. And I think we need full-time court managers. Full-time court managers, not just district judges coming as registrars. That is, I think they do not have any concept of time management. I think we need full-time court managers who will be able to paper management, brief management, time management, all these, you have to do it in a systematic manner. And therefore, then case management is important. Therefore, case management hearing, don't ask the judges, sitting Supreme Court judges, sitting as chamber judges, to do case management. Nor should we ask the Registrar General or Registrar, because I think they are just not trained for that. You need persons who are trained in this case management. For that, you need to undergo a special course. If need be, I think court manager, cadre should be separately organized. People should be trained in that in the law college, and they can become full-time court managers and thereafter become something else. And they should be able to organize, estimate the time limit, and on that basis, stick to the time limit and argue the case. I think that's very, very important.
So these are very useful suggestions, even as we look to the future. And so now I'm going to open up for the audience questions. There are several audience questions coming in. So what I'll do in the interest of time is maybe take common threads of some of these questions. And one common thread of questions is often you make an argument in court, but the judge simply says dismissed, or there is a very short order passed. How do you put across to a judge very politely, without looking over aggressive, that it is in your client's best interest to have some of the reasoning recorded? And this is a common problem we're seeing in the high courts and other courts as well, where you simply get only one word or only a line in the order. How do you deal with such situations?
No, I think high courts, they are required by the mandate of Supreme Court judgments to give a recent judgment. I think wherever there is a right of appeal, wherever an order is passed by any authority or any court, where there is a provision for an appeal, or there is a specially petition, a discretionary Article 136, but yet that is a remedy which is available. Therefore, the high courts will have to give at least a brief reasoning. I think that's a mandate, and Supreme Court has repeatedly pointed it out. Now, the Supreme Court, since it is a final court, it doesn't have to give the reasons, because there is no appeal against that. There is a review or curative petition, but there is no appeal. Therefore, I think it is also not necessary. In fact, I would strongly urge the Supreme Court judges to reduce the length of their judgments. There is no need to extract facts in the manner that they are doing. We should be able to put over only what is necessary. No need to extract all this. But I think on account of paucity of time, the judgments are long, because to have a first draft, correct it, and reduce the length, you need more time. That nobody has the time. That's one of the reasons. Therefore, the high courts will definitely have to give the reasons. And I don't think you can certainly tell them, look, I have made my submission. Of course, it's entirely for you as a judge to take a decision. But whatever it is, please record my submission and then give the reasoning. So that, because my client may like to avail of a possibility of a specially petition or an appeal. Therefore, that's something which you can certainly very politely request. And I think the judges normally do that.
Thank you, sir. And another common thread of questions that is coming in, sir, is on brevity versus the school of thought that says in your draft, make sure that nothing is missed out. That's one thread of questions. And the other is, what about legalese? Because again, a school of thought in drafting is saying, listen, don't, because you use 5 Latin maxims, doesn't mean that the judge is going to grant you relief. Put your language, simplify it. So what about legalese also versus brevity in drafts? So could you just talk specifically to that a little?
I would certainly commend the simple language. See, ultimately, our language, it is for communicating the point. We should be able to communicate to the client. We should be able to communicate to the briefing lawyer. We should be able to communicate to the judges. Now, I think there is no special, attraction to the Latin phraseology if we can put it over in simple words in English, I mean, whatever this one. So, one, brevity and whether or no you should never leave out any point. I personally feel, particularly when you are in a discretionary jurisdiction in the Supreme Court, in 136, you may have 100 points. It's not going to. That's why I said, first appeal and second appeal. Section 100 talks in second appeal of the questions of law. There is an art, there is a skill. If you are not able to cull out that question, and it can never be more than 4 or 5 questions in any case. You should be able to, there is no point in making 20 different questions and each question running to very lengthy sentences of 20 lines. It doesn't make sense. In 3 or 4 lines sharp, you should be able to focus and brief. I think, see, there are very, very few cases where multiple questions would arise. Most cases are of a nature where 1 or 2 questions will be involved. When 1 or 2 questions are good enough, if you have 20 questions, the judge has to spend time reading it. He will get fed up. So the good point also is lost sight of. If you are able to catch his attention with the best point, I think you should do that rather than going into. And if you are not able to succeed with that, it is unlikely that you will succeed in the others. I don't believe that. You see, there is a difference. In a original proceeding, you can't miss out anything. But in an appellate forum, things are entirely different. Whatever needs to be said has already been said in the original proceeding. There you can't leave out any facts. So that you will have to raise that.
Right. Thank you, sir. Another question that's coming is regarding the moral attributes of advocacy. There is a very important facet to good etiquettes in advocacy, in moral attributes of advocacy. Are you seeing a decline today? And we're not talking just judiciary-wise, but the bar, the legal fraternity as a whole. As you look over the last 50 years, are there things that today you would want to tell younger lawyers with regard to moral attributes and etiquette that you feel are being eroded today, or things that we can learn?
See, when I started the profession, the seniors in the profession also would have had the same feeling. Look, in our time, things were different, and today people are coming in and starting. Therefore, I don't think it's going to, as we see, for 50 years from now, when we are older, I may not be there, but when you are older and there are younger people, you will look at it differently. But I don't think that makes a difference. This generation gap is not much of a problem. But I think the value systems which were there immediately after we got the freedom. The freedom struggle, people were focused on getting liberty. They sacrificed so much. So the value system was very, very different. As we travel in the after 47 and 1950, and then our local democratic elections, now over a period of time, power which was meant for public benefit, to be used for public benefit, when you find that people in power are using it also for their private benefit, there is a lot of resistance to that. There are some who feel, okay, if these big leaders, so-called leaders are doing this, why not we do that? Therefore, there is a change in mindset. In our time, 70s, when the emergency came, the number of people who were willing to take the risk and go against the government among the lawyer community was huge. So when Mr. Venugopal used to come here to Delhi or go to Bangalore or Bombay appearing for the detainees or for the political leaders, and I used to accompany him also. He was being followed. The IB used to follow, his phone was tapped, but we all knew there was an inherent risk involved in that, in appearing in those. But I think we were more idealistic in that time. I think the lawyer community as such, they were willing to go to the street. You know, to have a copy of the Indian Express or the Statesman meant that you are somebody who is opposed to the government. And I have seen hundreds of lawyers in Madras High Court premises who used to carry the Indian Express only to show to the world, look, I am one person who is opposed to the government. That used to be the kind of approach. But of course, today the media has also changed. You don't have so many of them who are willing to fight the government. But the lawyer community also, I think there is see, we have all got used to the comforts of life, the security of life. We are more intensely focused on that. Oh, look, there are people who are fighting. Why should we sacrifice our comfort and our family's comfort? There are perhaps I may be completely wrong. There are more people who are willing to take the risk, and I'm not one of them. It may be, but I think during the freedom struggle, the lawyers were more committed and focused on getting the freedom. During the emergency, there were more lawyers willing to take the risk and fight. I think as days have gone by, today, there has been, look at the chairman of the Bar Council, as Mr. Ramjatnani or Ranjit Mohanty, they came out openly and then they're willing to fight the government of the day and criticize them. But today, what do you have? So the leadership that you have in our Apex organization, the Bar Council, today, I don't know, I am personally not aware, I can't speak, but then the judges in the open courts have said, look at what is happening in the Bar Council election. Is there the kind of principled fighting, or is there constituencies and lobbies built up, and which elect today the leaders of the bar? I think this is a question we must ask ourselves, introspect and reflect. I think, therefore, but at the same time, we must also realize that it is from us that the Bar Council leaders emerge. It is from us that the judges emerge. Therefore, if there is a deficiency, the deficiency is in us, in each one of us. So we have to correct ourselves.
Right. So let me close with one final question to you, and that is, over your last many years of experience, what are some of your learnings that you want to share with us? All of us aspire to become the best advocate that can be. What are some of the life's lessons to become the best advocates we can be that you would advise us to inculcate?
I think I have shared my life experiences, some of them. I don't think there is much, but I think, see, we exist in a system, and therefore we cannot undermine the system. We cannot, I think, see, though there may be some people about whom you may have doubts, never ever attack the institution. Number one, I think this is important, because if the institution doesn't exist, we don't exist. From within the system, work, if there are some persons who are harming the institution, the repute of the institution, try to weed out that. But don't make it public, because public confidence in the institution should never be shaken. I think we have to be conscious of it. This is one. Number two, I think we should never give scope for anybody saying, look, you have consciously or willfully misled the court. I think your reputation is built. You may lose a case today by putting forth everything, but the judge remembers, if you have put forth the facts correctly, if you have pointed out the law correctly, if you know that a case is against you, you must be able to point out and distinguish it, or say that it requires reconsideration. Never ever withhold. If you, even in the least, in the worst cases, your success depends on your judge accepting what you say as correct. I think a lawyer's reputation is built over years on this. If you start misleading the court, that is a message that not only one particular judge will have before whom you have argued, he will tell his brother judge when he meets him in the evening. He will tell his sister judges when he sits with that judge tomorrow. Therefore, don't allow that kind of a reputation to be built. You may succeed today, you may not succeed today. But if your conscience is clear that you have put over the best for your client in the honest manner that you want to discharge your duties, I think that's good enough. And that's what I would say is an important lesson that all of us must have.
Sir, thank you so much. There's one aspect I think the audience would also like to know, since you served as additional solicitor.
Yes, I did. For a year and a half, for a short period, I did just serve as an additional solicitor general. A law officer's job is a very difficult job, because you don't have the luxury of time in preparing cases for the government. Most of the cases come to you the previous night, and then you have to get ready. It's a thankless job. I must give full credit to all the law officers who are functioning today there. And it is a very, very difficult job. And I think they are doing a good job. I think there is some connectivity problem. Thank you. Thank you all.
Sorry, sir. I think Abhishek has dropped from the call. It was a wonderful session, sir. Actually, I handle the tech side at LiveLaw. Even for an outsider, it was a very informative session. I think thoroughly
thank you very
our
much.
audience would have enjoyed.
Thank you
a lot, sir.
Yeah, thank you. I'm sorry we lost internet. We lost internet my end. Thank you so much on behalf of all of us.
Thank you.